Very good morning to each one of you. On behalf of the Bangalore Chamber of Industry and Commerce, we welcome each one of you for this first day of webinar on IPR and patent registration. This will be followed by prerequisites and procedures for registration of trademarks tomorrow, same time. This session is being organized under the aegis of Banking, Finance and Corporate Affairs Expert Committee of BCIC. We like to specially thank Dr. KB Om Prakash, Chair of the committee and advocate and founder, Director of Consortia Consultancy, and Dr. KSR, member of the committee and managing partner KSR and Co, for curating this session for the benefit of our members. The today's speaker is Mr. Santanam Lakshmanan, Chief Executive KSR and Co, Company Secretaries LLP, Head Industrial Audits and Patent Agent, and he will speak today on IPR and patent registration. The session will be moderated by Dr. KSR, member of the Banking, Finance and Corporate Affairs Expert Committee BCIC and managing partner of KSR and Company, Secretaries LLP. On behalf of the BCIC, we express our sincere thanks to Mr. Santanam Lakshmanan for accepting our invitation to address on this important subject, which will definitely benefit our members for this morning session. We also would like to thank all the participants for joining in today's session. We also would like to acknowledge and thank KSR and Company Secretary LLP for being a supporting partner for this two-day virtual session. We request all of you to kindly mute your mic and webcam options. This is to enhance and keep the bandwidth strong as well as avoid any disturbance in the background. Please post your questions in the chat box only. The speaker will respond to the questions during the session. May I now invite Dr. KV O. Prakash to do the welcome address and take forward today's session. Over to you, Dr. Om Prakash, sir.
Thank you, Prithvi, and hope I am audible.
Uh,
Yeah. Thank you, Prithvi, for this brief introduction. First of all, I would thank our K.S. Ravichandran for organizing this wonderful session that is a very important topic, IPR and patent registration. I welcome the speakers for the day, and also I thank KSR for having sponsored this event. I welcome all the participants, attendees for this wonderful 2 days workshop on IPR. The IPR basically we can classify into three segments. One is for the copyright, trademark, and patent. So for any company, intellectual property is very sensitive and confidential. And for the brand purposes, it's very important to register, protect. And next 2 days, we are only going to see how branding protection is important for any company, any entrepreneur to safeguard his trademark or trade secrets. So we will be running through the various procedures, case laws, and various aspects of the IPR. I welcome once again everybody, and thank you very much for joining us today. And I expect all to join tomorrow as well, because we have the sessions continuing in good large number. Please spread the word to the friends also. It is very important and very informative session organized by KSR. Thank you, sir, and over to you.
Very good morning to everyone present here, and first of all, thanks to the BCIC for organizing this very important program in a very important city called Bangalore, where a lot of things are happening in terms of intellectual property rights and development of intellectual property rights, implementation of intellectual property rights. And we are in a city where you know that Hindustan Aeronautics Limited is situated, and we are discussing about aircraft like you know, the new generation Indian version of fighter aircraft. You know, that is the kind of place we are sitting, and everywhere information technology and technology is being talked about. And BCIC, in terms of choice of the subject, I would like to emphasize that it is a beautiful subject which has been taken up by BCIC for probably helping emerging inventors, innovators, and entrepreneurs, businessmen to be conscious of various species of intellectual property rights. And you know that the patents, importantly, in the last, I can definitely say from the statistics, in the last 3 years, we have seen in India several applications having been filed for domestic as well as international patenting. Now today, those were the days when we used to think, okay, we need to create awareness, we need to think about it, and there were a lot of apprehensions in the minds of people whether the invention, if it is revealed in the form of applications and specifications, will it go to somebody else, how they will feel it, whether there will be a secrecy lost, whether there will be issues with respect to the problems of somebody else immediately copying and doing an invention, doing implementation. Those type of apprehensions, those days have gone, in my opinion, from the way in which we interact with our clients in our firm. We understand that today people are coming forward to but it is so much so that at the drop of a hat, they would like to see whether it can be patented, whether this is something which can be done. Is it sufficiently an innovative process or product, or it is an invention, something like that. So we have sufficient experience. I don't say that more than 2 decades we have been associated in this IPR field, be it the patents or trademarks or copyrights and industrial designs. You will find way back, long back, I remember when I was sitting with Padma Shri Krishna Kumar ji, he was telling that the Chawanaprash in what you can say, in a messy form, in a liquid or a precipitated form, children won't like to eat it. Though it is very important in Ayurvedic thing, Ayurveda, they make all these herbal related medicines and all harmless things. So Chawanaprash was one of the most important products people used to consume for the purpose of general health of a person, and particularly for kids. And if it is messy, I don't think people will look at that type of thing, which is like a paste, and they will not be able to carry it to the school. And that is the time when this Ayurveda pharmacy of Coimbatore brought out what is known as biscuits, which is very difficult process, where Chawanaprash is made into biscuits, and we were advising the client, and we got it patented for the first time. Long back, I'm telling about 20 years back, Chawanaprash was brought into biscuit form, and we got it patented. And similarly, I very distinctly remember a very beautiful engineering issue, which was raised by the Research Designs and Standards Organization of the Indian Railways. And the problem was about unwarranted brake pressure building in the pipeline, whereby suddenly the coaches, there will be a brake applied when the moving train, and if the intensity is not much, what happens is the train will keep moving, though the brakes are applied, and it can cause into difficulty. When intensity improves, there could be skidding. This type of things led to the invention of what is known as the brake binding indication and isolating device. There was a specification which we filed with respect to these type of inventions, where very loss of human lives can be saved by such type of process like the brake binding indication and isolation device. N number of such specifications are there, which we can keep on illustrating and discussing. The idea is, whenever in the ideating stage, whenever it is in the ideation stage, incubation stage, you may be requiring an advice to know whether it is something like to be patented, what are the advantages, how much it will cost, where it should be done, and all those things. So, and if you see the Patent Act, it has come of age, and a lot of provisions have come, and it is very efficient now. It is one of, as we have done in several countries, we are able to understand that India is no way lagging behind in terms of provisions and procedures and processes. And this brief introduction, I would like to invite Engineer L. Santwanam, our Chief Executive, and also the patent agent to make the presentation. Thank you.
Thank you, Dr. Ravichandran. Good morning to all. I thank BCIC for organizing this event, and also thank Dr. Om Prakash and Prithvi. So, as the introduction was given by Dr. KSR, so IPR is one of the important aspect of industrial progress of a country, and we will just see briefly about the IPR, various IPRs, just an introduction, and then switch on to patent. So let us see, hope that this session will bring some good value and interest to all of us. I'll just share the screen for my presentation. Hope I'm audible.
Yeah, very much.
Okay, thank you so much. So the topic is about an introduction to IPR, various IPRs, and then prerequisite for registration and grant of patents. So generally, what is an IPR? It's an intellectual property. So intellectual property means a property which is of mind value, so which is intangible. And it can be in the field of industrial, scientific, literary, on any artistical fields. So the rights are safeguarded of creators and other producers of intellectual goods and services by granting them rights. The various types we have. These rights are exclusive rights with time limited rights. So like for patent, 20 years is given as the time limit for the holding the rights. And in case of copyrights, if you see the 60 years over and above the life of the creator. So likewise, each legal aspect is there for each of the IPRs, like trademark and designs. Then other IPRs which are joining the bundle is layout of design for IC circuits and graphical indicators, then trade secrets and protection of these are all joining up now and are picking up this memento like geographical indicators. After this is coming in, the trademark has got a new restriction in terms of use of those products and things from the specific region or land, like Darjeeling tea. One cannot use the word Darjeeling in just like a general way. So those are the new restrictions came in the trademarks. So like any other normal rights, property rights, the IP rights also can be used for owning. It can be leased out, it can be assigned to other person through a licensing or through an agreement, can be sold also, or one can buy the license. So out of the major things, so we will be talking about the patent. One is that it's an exclusive right granted to the inventor, either for making a product or for a method, process, or designing an apparatus which may give a novel way of doing the things and giving a technical solution for a problem existing. And as per patent, if you want to see pure inventions are very less, we can say about 5% only. And 95% is about improving the known technology. That is, one has to study the prior arts available and see what is the improvement, whether the ease of doing or bringing in commercial value. Likewise, that's how this is spread across, and industrially the country is developing by inventing on the mind power through this type of new inventions and protecting them through Patent Act. So this is, the patents are valid for 20 years, and the Patent Act 1970 is governing the law. Then industrial design, another one which is close to this technical aspect. This is about another creative aspect. We can say like which is design of the outlook. Mainly what attracts our eyesight is what is counted over here, like jewelry design or any of the new cars or new products which is appealing to the customer or consumer. So those things can be protected through design protection. So governed by Design Act 2000, and the term of registration is 10 years and can be renewed after every 5 years further. Then layout design for some more big, because I'm being an engineer slightly, I'm talking about those engineering aspects. Anyhow, trademarks we'll be talking tomorrow. Our other colleague will be talking about it in detail. So we have, especially electronics has improved in the leaps and bounds as on today, and printed circuit boards are very inevitable for going into the microchip chip level. So these circuits are to be protected for the it is being designed and products being so that's about a small brief on IPR. So patents being the one of the techno legal aspects of our IPR, because it needs a technology as a base on which an invention is being brought up and then protected through patent rights. Now, just a small wild talk about what is this, can ideas be patented or protected? Any idea? See, any creation starts from an idea, be it be a kind of artistic design, or it can be any kind of industrial patent or invention. So in case of copyright, it protects the expression creative works. In case of patent, similarly, we protect the invention. So idea, is it an invention? Idea is a small spark which comes up for the person in the field, and he wants to bring in some improvement to the existing, or can be a new design or product or process. So these ideas can be developed into invention through proper study and then improving the technology. Once you have an invention, then you have to immediately protect it. That is what we say. Immediately when it qualifies for a kind of result-oriented technology, then we have secret is those ideas, methods, or technology which is protected within a small group or the enterprises or a family or something like that. Whereas the idea of patent is to protect for a certain period, and after that to open to the public for further development, so that it bring the benefits to the country and the people as a whole. So do an invention and put it into the patent system, then get the protection. So catches can breaking into result to end. So we need to be very much careful there. Protect by applying through the patent system. So once you put it there, you get a priority for your invention, though you must be developing it further. So you may have the developing, then you may have to test it, all those things may be pending, but one to keep the the dates are very, very important in the patent filing. In case all the IPRs, it is there invariably, and this will give us good mileage when you have similar patents available or similar inventions are being done by your contemporaries. So when an idea is matured as an invention, it is absolutely critical to go for filing. How the patent process starts. So you have to take the first move, and the patent filing or patent prosecution and patent protection costs, really it costs. And once a good patent is pursued, you have an advantage of investment coming in. So those who are commercializing your whether it is product or process or the operators or machines which you develop can bring in the revenue back into the system for the hardship of the manpower and money power spent on this. So there needs to be a drawings developed on this technology, which would explain about the whole process and make the flow of the process. Again, one question will be there to search or not to search. This is invariably, many consultants, they keep giving an option for search or not to search, because as we learned and we always advise, search is a mandatorily required aspect of patent filing, because pre-filing application, because the strength and weakness of the invention will be known by knowing the other prior arts available in the field, without which we will not know. The inventor will have his own idea of telling that my invention is unique, but a consultant like us and a patent agent, a consultant or attorneys can only guide them about what is available in the field, what is the strength of this, whether it can give through or can be objected or rejected through various invalidation processes. So, for that, a search is very much essential. We always press on it. So again, first to file, it is like bringing like our date of birth. When we take birth, we know what date we are born in this world. Similarly, the patent application, when it is filed, it gets the birth date, which is called priority date. And that is very, very important, because in the event of contemporary filing on the same date, the timeline in which it was filed will be taken for seniority for the same invention, if at all, if it is for the same clients. So the patent life cycle goes like this: an idea gets converted into invention, then through guidance, it is converted into patentable invention by study and other techno-legal aspects, putting into it as per the system requirement. So then prosecution in the patent office till its grant. It's like maintaining the whatever legal requirement or queries raised by the patent office. So one has to respond to it again, timely response. Post grant, the protection of rights of patent is another thing against infringement or misuse by a third person. So what can be patented? In order to be patentable, pass through main 4 tests, which are essential. The invention must be a technology-based process. It may be on the machines, new machines or improvised machines. Then manufacturing, composition of matters, and new uses of any of these above, like known, if at all, as I said, 95% is known technology. One will bring the improvement, seeing the other requirements are like, if you see, every year we get new versions of mobiles. We just throw off the old ones, new aspects, new provisions, 4G, 5G, now it is going to elsewhere. So these are the new things which always develops, and it's an inventive step into the existing technology. Everything is a mobile only. So it must be useful. there should be an utility value for the invention or the patent application what we are applying for. So without which it's of no use. Then it must be novel, means new. New means again, it should not be known in the public domain. There are restrictions. There are provisions what is permitted and what is not permitted. We will just go through in the times, in the later slides. Then it should be non-obvious. It should not be a simple process where everybody, any layman can understand what is it all about, and it is not a known thing. So what are the summary of the salient features of the patent law? So it can be patent can be provided for product, process, and also the operators. The term of patent is 20 years. So there is a examination of the patent, which is on request. If you don't request, your application will be abandoned. Again, it is a timeline critical. Then there are fast track mechanism for disposal of appeals. Then there is another important thing of with respect to in line with the TRIPS agreement as a global requirement, and also our own interest. Protection of biodiversity and traditional knowledge. Declaration has to be given when the application is filed, so that this is not endangering any of the biodiversifying aspects, or it is not a traditional knowledge. Again, we want to say that here I just want to emphasize on the patents for our own known medicine, like the importance of garlic, importance of ginger, this turmeric, all have been the US has tried to patent it, and we objected, and time to time, and retain those value-based our practices in case. Then publication. There is a timeline at which the patent application will be published for after 18 months. So during this period, it remains as a secret within the patent office from the day it was filed till 18 months. After that, it is known to the public. So the very idea of patent is not to keep the invention secret to the inventor. The monopoly is available for him, for his own clients, not to any improvements which can be done by any other person. So it's an opportunity for other people, other inventors to develop, and also the value to the country and people of the country, and as a whole world also. And there are statutory fee concessions for startups and MSMEs which are available compared to any other big corporates. MSME get almost 50% discount. Startups get very least, this one. And also an individual applicant and startups, the fees is same. I'm not going into detail of the fees. Anyhow, this is very clearly available in the site. Then there is a concession for e-filing for encouraging the digital aspects. 10% discount is available for e-filing that's in the statutory fees. Then startups have this fast track for early publishing, early examination, and also early grant. If normal period is somewhere 5 to 6 years for grant, for them it may come about around 3 years. What are the, again, coming to patentable invention, one more thing, as we were already spoken, it should be new or novel, the idea, the invention. It should involve an inventive step, and there should be possibility of industrial application. It should be able to be used in the industry, and it should not be invalidated by disqualification sections like 3 or 4. We'll go in detail into it. Then new means should not be published in India or elsewhere, and should not be used earlier in India or elsewhere, and should not be claimed before in any of the other specifications. So coming to exclusions, So there are from section 3 deals with the exclusions, which is the first thing one will do, whether my invention falls under this exclusion category or not. From A to subsection A to somewhere O it is there. I will not go into details. Only a couple of things I just want to talk about it. So section 3A says invention contrary to the well-established natural law. So there cannot be any perpetual machine. So some machine which is non-stop.
Santaramji,
Anji,
your screen is not moving. Is it the same you want to retain? Sell your ideas. It is standing there only.
okay, I'll just share again once again.
Please.
There.
Okay, thank you.
Is it okay now? Section
yeah, fine. Go ahead.
So 3A is something imaginary aspect of idea which cannot be practiced. So that is not possible. Again, section 3B says commercial exploitation, like there should not be any invention which is contrary to the public order or morality. So like example, any kind of gambling machine device for basic, which can endanger health or human, or any of this biological warfare material, such things. We do not know whether COVID was one of it. It's a kind of doubt I just raised on that. So it's still to be established. So in the same way, section 4 deals about something related with atomic energy. So these inventions related to uranium, thorium, plutonium, radium, these chemicals cannot be patented, or one cannot invent on this. It's a government related, where a lot of things which is can endanger the public order, and it's protected thing. Then section 6 talk about who can apply for patent. So patent can be applied by any person. It can be Indian, or of international applications are being filed by an international applicant. So through TRIPS agreement, the same kind of treatment is given to any of the inventor, whether he is an Indian origin or outside India. Similarly, for India, there are under this agreement, it is there. So any person claiming to be true and first inventor, so can apply for patent application. Then any person who is an assignee of this who has got an assignment from true and first inventor. An inventor can be a part of an organization. He can assign it to the company, corporate itself as a whole. An inventor, then applicant becomes the organization. Similarly, one can assign to the venture capitalist itself, or any other corporate company. So soon after the development of the invention and getting it to be patentable. So likewise, there is a provision there. An assignee also can be a patent applicant. So, or a legal representative of a deceased person. After the invention, immediately, one person dies before applying, so his legal heirs can apply on his behalf. So this can be applied by any single person or a team of person, and there can be more than one person who may be the part of inventor or applicant even. So some of the stages, just I'll run through, from the start of filing to the grant. So file an application in any of the patent office like Chennai, Mumbai, Delhi, Calcutta, etc. So wherever it's nearest to your jurisdiction, pay the record fee. Then most of the informations are available under the IP India website. So guidelines to the applicants are very clearly available, but you always need a specialist to give the inventor the real knowledge and safeguard his interest. Then the registry does a formality check of forms, the right fee. Then immediately they give the receipt. So the receipt becomes your birth certificate of the patent, or we can say priority date we obtain as soon as we file the application, be it be provisional or complete specification. So section 7 deals with the form 1, which is the basic information of the applicant and the type of application which is being filed, whether it is provisional, complete, or an international application like PCT or conventional application. So it is followed by form 2, any provisional application to be followed by a complete specification within 12 months. So whenever we apply for provisional specification, one inventor can think that his patent is in pending. He can keep talking about it. He can start publishing about it. He can attract venture capital, all those things. He can develop, if it is a provisional specification, he can develop, make a prototype, test it, all those things. And before complete specification filing, he should be confident enough about the workability of the patent, of the invention. Then section 8, in case of foreign application, this is through form 5, one has to indicate the patent office about the undertaking, about the details of foreign application, if it is there or not, yes or no. If it is yes, with details. Then section 9 deals with the provisional specification, a type of provisional specification, and it says within 12 months, if at all there is a delay in filing due to some specific reasons. Maybe there is a development delay. There can be natural delays due to, when we started filing one of the application during 2015, there was a big flood in Chennai. Even the patent office got flooded. So that also was one of the reasons when we intended to take some kind of deferment of the date of filing. Post-dating of the application was permitted under section 17 of controller's power. So those aspects can be availed through this. Then section 10 talks about the overall form 2, the description, which is the main, we can say the core document of the patent. So it is divided, starts from a title, then what is the title requirement, everything, like it should be having 15 words, the limitation is there. And there are other things about the background of the invention, which industry it falls in, then small summary of the invention. Then comes the detailed description and the best method of doing it has to be explained, supported by drawings. Then comes finally the claims, which is what one can get patented. The patent is for the claims what the inventor makes, the applicant makes. So those industrial aspects will be passed or rejected or asked for amended based on the availability of the prior art or the examination through the examination stage. When it passed through, it will go into this one. And also the last thing what the document will have is the abstract, a small brief about the whole thing, the invention, which will be published. Section 11 deals with the priority dates of the claims of the application.
I'm sorry to interrupt, sir.
Yeah.
But I think the slide is still freeze in section 6.
Oh, I'm sorry again. So just a small, nutshell of the whole patent life cycle, right from the application filing till the grant of the patent. So I hope this screen is visible. Okay. Patent flow chart.
Yes, sir. Yes.
Okay. So when you file the patent, it may be a provisional specification, pending some developments, or it can be a complete specification directly. So if you file a complete specification after a specification means provisional within 12 months, then it will go to the publication stage as per section 11A post 18 months. If it is not filed, then the application will be abandoned. That is, when provisional specification is filed within 12 months, one has not filed the complete specification, it will be abandoned. So in case if there is a delay due to some specific reasons, one can ask for post dating of the application through other provisions in section 17A and section 9.3. So that can be availed where the priority date gets shipped. If at all, if you are delaying by 2 months, the priority date also gets delayed by 2 months. It's just shifting the priority date. Then once as per section 11A, if the publication of the application is done, then the inventor can think that he has got as if he has got the patent, because from there onwards, it will be on next step will be the examination stage. So till examination, it will be in queue. The application as per seniority, it will be called for, and so there is a provision for even early publication also, like startup and other, anybody can apply for. So sooner, after applying for in 1 or 2 months, the publication can be done. That is between 12 to 18 months. Within this period, it can be done. Maximum is the 18 months. So then comes the request for examination, the next stage, which normally starts at 48 months. There can be also request for expedited examination by applying for 18A form. This is applicable only for startups and those international applications where India is the international has been selected as international search authority. So those are the two conditions under which expedited examination can take place. So within this stage, after the publication is done, there can be anybody can object the application. This is called pre-grant opposition under section 25(1). So any person can object on various conditions. It may be invalidation of section 3 or 4, or prior publication, and there are various subsections under this clause through which one can do the opposition filing. Then once the examination is done, during this time, section 13 and 14 of the Act will be applied by the examiner, and he will submit a report to the controller. The controller then scrutinizes and finally will be sending this to the applicant for his reply. Generally, there will be some of the citation, that is prior arts, shown to as a similar claims or for similar invention. So one has to justify his cost and give a reply within specific time. And then once the reply is done, once the examination report is received by the applicant, he has to, within 6 months, he has to put the things in order, and there will be a re-examination done of the reply. Then controller, if required, will offer for an hearing. So any objection not met within that 6 or 9 months maximum period, then application will be abandoned. Then in case of objections met within this period, then as per section 43, patent will be granted. Now, I was talking about the opposition part. One is soon after publishing or before grant of patent, pre-grant opposition can be done by a third person, any person who can do it. And post grant of the patent, any interested person who is in the field can only apply for the opposition within 1 year after the grant of the patent. So this is how the flow chart which runs from filing to the patent grant. There are some small special provisions which are available in the various sections. Just a few things I just want to highlight. Like what happens if an inventor discloses before he applies for patent? Is it anticipated or not? We call it anticipation. When it is prior publishing is an anticipation as per patent language, patent law language. So in case of prior publication of the invention, there is a maximum time. Normally it should not be done. Better to do it before you disclose. Always it is safe. If at all, if it is so happens that you have to disclose to a government organization or a select people, interested people, or you are able to have the presentation done to your school, college, or within this closed group, even then, within 12 months from the date of publishing, one has to do the filed up complete specification, not provisional. So very important. This is under section 31. This provision is given. So this is one important aspect for the people who are budding inventors. Then again, as we were telling about post-dating, like if there is a delay from provisional to complete specification filing within 12 months due to various reasons, it may be natural calamities or your own difficulties, or development is not happening, or there is a fund required, all those things. So one can get the post-dating of the application with controller's permission by applying for under the section 17(1). So there will be maximum delay of 6 months, but it will be at the cost of losing your priority date by that much time period. Under section 9(3) again, so there is another specific aspect of, once one person has already filed a complete specification, after that he develops some more things, and within the 12 months of period of complete whatever the initial application filing, so he can request for treating that previous application as provisional, and the improvised thing will be can be treated as complete specification. But all these should happen within 12 months. Otherwise, your pursuing of other aspects of the life cycle will start. So one has to do within 12 months. So in the section 11A again, as I said, expedited publication one can do. Then another, this slide talks about the important timelines during the prosecution of Indian Patent Office. So as I said, provisional specification, Form 2 has to be filed within complete specification within 12 months of provisional specification. Then it has to be accompanied by Form 3, which is an undertaking regarding foreign application filing. If you don't do it, the application will be rejected within 6 months. It has to be filed. If at all you have whether you have or not, it is to be told whether I have an international application or not, file. Then request for examination. If you don't request, the patent application will be abandoned. Maximum period is 48 months. Form 18 and 18A with the requisite fee to be filed. Then declaration of inventorship, Form 5 is also to be filed within 1 month of initial filing. Better to file along with the main application. Then again, time for replying for the first examination report, very important, within 6 months from the issuance of FER, extendable by 3 months maximum. Then pre-grant opposition, one has to do soon after publication, before the grant of patent. Form 7A, one has to file this. Again, we did this very recently for one of our clients, where I know unfortunately he has published this findings in LinkedIn. So someone reached out through messaging about this looks like our patent, a person from foreign country. So he says it looks like our patent, and we have an application filed in India. Then he requested for us to search about this application, and so immediately, because it was ripe to be granted, like it was crossing the 4.5 years its duration in India, any time it would have been granted. The best time is to apply for a pre-grant opposition. So we filed a pre-grant opposition, putting various justifiable opposition supporting that client's interest, and still it is in the pursuing. Still, it is not been granted. So if at all one missed this, can go for the post-grant opposition. If unfortunately, because developing this this one also needs very big research. We almost developed a 200-page document to be submitted to the with evidence, everything. So it's a big process again. So one can avail the post-grant opposition. Same person can apply for post-grant opposition also if at all he has already applied for pre-grant. He provided he is an interested person from the same industry. In case of pre-grant, any person can apply. So whether he may be interested or maybe in the same field or not, one can do it. Then so another thing is, if it is a biological material, something related to microorganisms, so one has to deposit the biological material. So after the grant, Form 27 has to be filed to always say every year, annually, regarding working of patent, one has to give the undertaking. Then I'll quickly run through other areas of the patent filing. Hope the slide is moving. Is it okay? So Section 54 talks about patents of addition. Like, once the patent is granted,
Excuse
the
me,
patent,
sir.
yeah.
So the slide is still on the patent flowchart.
Okay. Sorry for it. Actually, I think the network is slow. Sometimes it hangs around. So the slide, important process after grant, is it visible? Okay, Section 54 talks about patents of addition. Like, once the patent is granted, if there are improvement done, so for the same patent, the inventor can add on another thing, and with the permission of controller, can get the improvised patent included into the main patent. Then in case if the renewal is not done on time, Section 60 permits restoration of lapsed patents. Within 1 year of the period of the lapsing, one has to apply for it. Section 60 guides about it. Then there is another section, interesting section called Revocation of Patent. The revocation of patent can be done by any third party through application, litigation through the courts. He can do it. And Action 65, Government of India, if it is the invention is about something protected technology, they can approach the patent office for revocation. Again, if it is Section 66 talk about the public's interest. If the invention is endangering public interest, then the revocation of patent can be applied for, like it is environmentally endangering, something like that. If it is the fumes are coming out, and if it is dangerous to the well-being of the people or the atmosphere around or the species around, so that can be revoked. So Section 84 is another aspect which is deals with the compulsory license. If at all, if the patent is being granted, and after grant, if it is the compulsory license can be granted. If at all by any interested person who says that there is a very least public benefit from this patent, or if the pricing of the product or services is very high, and if the patent is not working in India, in these circumstances, compulsory license can be issued to a third person, provided the patent after grant 3 years has been spent. So in case if there is a justifiable reason, sometimes after the patent granting, there may be difficulties, practical difficulties, like a change of law of government, because of which he is not able to pursue the production of or manufacturing of the certain thing, if new rules have come in. So in that case, the controller can give additional time period till that gets sorted out, or in case any court case is there on objection of for revocation. So all those things can be passed by controllers pursue. Then Section 92 again deals with the compulsory license for Government of India. Like any national emergency, like in this case, COVID-19 is one of those situations where we went into national emergency for expediting the production of vaccine. A lot of things have been done, supported to the inventor, especially Bharat Biotech as an indigenous company of India. There was before no product can be allowed to be used before proving its efficacy. In our case, it was on fast track. The government has done through their support. In the case of the Pune Institute, it was the UK developed vaccine which was licensed to be manufactured in India. So with the fast track methods permitted globally, has been availed during this time by giving the compulsory license. Even under exceptional cases, the emergency medicines can be imported through this channel. Like India has sent the basic medicines all over the world for developing the immunity during the COVID period. Then Section 99 to 102 deals with invention for the purpose of government. See, the invention is, though the owner is the inventor, it can be treated as the property of government again. If the government is so interested with the public requirement or for the benefit of the whole citizen, it can acquire those inventions on its name and giving the requisite compensation to the inventor. So those things are dealt in 99 to 102. And again, Section 104 talks about the jurisdiction of the. So there is, if at all, if there is a, whatever the controller gives the direction, if the person is not happy, he can reach out to appellate board. Then there, wherever the controller's power are there, right from the application stage to the grant stage, any of these things can be taken to the appellate board. So they can give the their verdict on to the thing. If at all, if it is further not satisfied, even with the applied board, one can reach out to the courts. The jurisdiction is basic is minimum district court and above, and any infringement will be dealt by high courts only. Section 105 to 107A deals with infringement suits and its defenses. So Section 108 talks about the relief in suit for infringement, which can be generally of injunction, that is stopping as it is the state at which and stopping the production of the other defender. Then damages for the whatever damages or can account attach an account of profit to the applicant. So I just want to talk about general patent application filed during the 2019. This is taken from WIPO database. If you see, China is the front runner in patent application filing. So their resident filing is very high compared to foreign application filing, orange. Hope you are able to see the
No.
slide?
We are not moving it.
Oh, I'm really sorry. Is it visible now?
Yes.
Okay. Now, if we see China comes first and US comes second, the difference between is almost twice. China is the front runner, and US, you can see that the foreign applications are higher than the indigenous application. Japan comes third, and India is the seventh place, where you can see the resident applications are almost, if at all we see the ratio, it is 60-40. Foreign applications are 60% and indigenous applications are 40%. This is much higher. We are improving, right? Compared to 4-5 years back, where we were not even within 10. Hope the slide more.
Yeah, very much.
Overview, I'm really afraid every time I'm have to ask. So overview of this is a PCT system. I'm talking about a small brief about international application. So one can file application within India, which is called an ordinary application, in case if it is a complete specification, or if it can be a provisional, then converted to complete specification within the 12 months committed period. So we can one inventor can pursue globally his invention also. So through TRIPS agreement, there is a PCT procedure through which one can globally apply. The treatment for the invention, priority date, everything will be done. The first file, like if at all, if I file in India, so we can pursue the application at US, China, any of the Asian countries, Europe, or anywhere. So this through the treaty, either it can be conventional countries. So in case of PCT application, there are about 174 to 178 countries are available as on date, through which this application will be available and will get the same treatment throughout as if it's a filed in India. So that is one thing. In case of conventional, there are limited countries where mutual agreement, Paris Agreement, Convention agreement has been signed between those countries. So those countries will have this through this method. So one can select whether PCT or convention, seeing the where you want to pursue. So it's a big process which takes a maximum period of 30 months. One has to follow. As it is, when the first filing in any of the jurisdicted patent office, if it is filed, then as per this one, international application has to be filed within 12 months along with the complete specification. Even it can be complete specification earlier also. Even if it is first filed complete specification within 12 months, you have to file the this international application. So as soon as while filing, one has to select international search authority, because there will be pre-search done by an international organization, of which India is also one. India, China, US, Europe. Likewise, there are listed 7 to 8 countries, Japan. Likewise, any of these ISAs we can select. So then comes the transmittal period from 12 months to 18 months, again, which is the natural publication period, what we were talking about for any of the application. During that time, it will be transmitted to the WIPO, that is Geneva, World Intellectual Property Organization. So which is the governing body for all of this, global understanding and treaties on IPRs. Whether it may be trademark, it may be patent or copyrights, any of these. So 18 months there will be search report, intermediate search report, ISR we call it, will be given by the ISA. One has to respond to it. They may have some citations coming up from there. Then even there is an option for the applicant to have pre-examination. Before actual examination, one can try a pre-examination done by the ISA of selected or any country ISA, so that he can have a valuation of his patent, if at all, if anything is there, so he can still have a time to improvise and again resubmit some of the small things, guidance which have been given, or justify the claims. Then finally, at the 30th month, the international application's life cycle will be over. Then the national phase of the application will start. So in case, if at all I have filed an international application in India, so my national phase also starts from 30th month. For next is the 48th month examination period. So what happens is the international other global areas, like if I want to pursue my application in the US, I have to interact with the local patent office over there, take help of patent agents who have the presence over there, and apply for pursuing this patent in their country. This will be, though it will be transmitted to the those offices, we have to pursue with the requisite fees. Then if at all, if it is a country where translation is required, language translation, like China will require to be converted into Chinese language, Japan to Japanese likewise. So wherever we have to translation is required. So likewise, again, this support is again required globally through the related agents, patent agents and attorney. And as per their local rules, this patent will be granted. And I'll just move to the next slide. I don't know whether it is moved.
Om Prakash, do we have 5 minutes more time? Or Prithvi? Slide has not moved, Santanam. Santanam?
Yeah.
Slide has not moved. It is already 11:45. I think 11:30 was the given time. So how much time do you need?
It's over. I'm in the last slide.
Okay, fine. Because some of the queries I am just answering in the chat box.
So I'll just, the last slide about how we take through this, whenever the query comes to us for patent application filing. So it starts with the preliminary consultation and analysis. We do the patentable analysis. We invariably do a patent search, indicating the strength and weakness of this, and also guide the inventor if at all any improvement to be done. Then filing the provisional specification if at all, if it is to be developed and the inventor needs some time. So we go for the filing provisional specification, we guide them. And later, as it develops and the inventor is ready, then the complete specification can be filed as an Indian application or an international application. Once again, we do a prior art search once more before filing, so that the claim strength is appropriate, so that it gets through for grant. Then finally, the international application, as we said, the 30 months period we follow, interact with the ISAs and support the requirement, and till it is reaching the national phase. And if required, we support the requirement till the grant and further also. So the presentation, sorry for the interruptions in between.
Can you just tell about renewal fees payable?
So, patent life cycle starts from the date of filing, because normally it takes 5 to 6 years. So we will be filing all these 6 years. When the patent is granted, immediately we have to file the annual fee for the patent for all the 6 years. So one can further renew it every year, or can compound it for 2 years, 3 years, respectively. So one should not be thinking that as the patent is granted, the annual fee starts from the date of filing. If at all, if I have filed an application in 2015, so for 2020, I had to file 5 years, annual fee at once, as soon as I have been.
May I interrupt, Santanam sir?
Yep.
Can we wrap it up? It's already 11:47. Can you rush to?
Yeah. Yes, we can. We have already finished. I just raised one question.
So we can spread over tomorrow also.
Yeah. So, Om Prakash, this I think Santanam has finished his presentation, I guess. Santanam ji?
Yeah, I have finished my presentation. I was just looking for questions for anything, if it is any important questions which requires immediate this one. Otherwise, one can post to our web, mail ID, which is given there.
We also have tomorrow. We can actually spread over.
Right.
Yes, very
great. So, Prithvi?
Yeah, Prithvi there? Okay, let us conclude it.
Screen share you can close.
Yeah, please, sir. Thanks for attending this session, all of you. Hope it was interesting. And thank you, Santanam and KSR, for bringing this important topic and threadbare analysis, and with a beautiful PowerPoint presentation explaining the whole thing. Hope the members have benefited, and all the attendees would have at least got some awareness about what is the patent, the various aspects, protection, the application, the initial registration, and also an overview about WIPO. So it was a wonderful session. I think thank you very much for the insight given by Santanam and also KSR. So let's meet up again tomorrow with the topics like trademark and copyright. And I would leave this session adjourned now for tomorrow's part 2 workshop. Thank you everybody for spending time with us and joining us for this wonderful workshop. Thank you, sir.
Thank you so much. Thank you so much.
Thank you.
Any questions can be shot tomorrow also, or you can send it through us, or you can post it in the chat box. We will get back to you.